Voting on changing the state constitution gives the Minnesota public a more direct role in decision-making. Producer Jon Brune looks at the process of enacting a constitutional amendment in Minnesota.
The Minnesota Constitution is a living document, frequently adjusting to the political landscapes of over 1.5 centuries. Hundreds of amendments have been proposed since the early years of statehood, many of which have been enacted. Changing the state constitution is designed to be more difficult than passing typical legislation. It is meant to allow the Minnesota public to play a more direct role in the decision-making process. And while there are many similarities between enacting constitutional amendments and passing typical legislation, there are also significant differences.
On that motion, all those in favor say aye. Opposed, nay. Motion prevails.
The process that's required for the enactment of a constitutional amendment begins a lot like the ordinary legislative process. A member of either chamber might think of an idea, a way they want to change the Constitution. They have that drafted and prepared in bill form, and it's then introduced just like a bill. And each chamber would need to take action on that bill the same way it passes ordinary legislation. In other words, the requirements for 3 readings on different days, etc. All the other requirements for passage of legislation apply. Once both chambers have passed the proposed legislation, the proposed amendment in the form of, in bill form, things begin to differ from the ordinary legislative process. Typically, the bill is submitted to the governor for the governor's approval. That step is symbolic only. Governors do not have veto authority over proposed constitutional amendments. That has been firmly established in Minnesota. There's been a long tradition of placing those amendments, proposed amendments, before the governor to allow the governor to weigh in and, in effect, demonstrate additional support for the proposed amendment and provide an opportunity for comment, perhaps, in case there is some difference of opinion. And after the governor has had the opportunity to weigh in and express an opinion on the merits of the proposed amendment, the Secretary of State then ensures that the proposed amendment is placed before the voters of the state in the form of a question that will appear on the next general election ballot.
Determining the number of votes required for a constitutional amendment to pass is an unusual process and also increases the difficulty of amending the Constitution.
When it comes to the general election, the very important distinction there is that there is a supermajority requirement in effect for passage of the amendment. And what that means is that a simple majority of the total number of voters voting in the election must vote for the amendment in order for it to become law. If there are 1,000 voters voting in the election, we know that 501 votes would be a simple majority of those voting in the election. And then let's set aside the proposed amendment and say that only 900 voters decide to cast a ballot or decide to vote on the proposed amendment. Ordinarily, a simple majority would be 451 votes, half plus 1 of the 900 votes. That would be insufficient to pass the proposed constitutional amendment. You'd need 501 votes out of the 900 in order to pass the proposed amendment. Anyone who goes into the voting booth on the day of the general election and doesn't vote for the amendment or against it, in effect, has voted against that amendment. Not voting is treated like a no vote because of the construction of the supermajority requirement for passage of the proposed amendment. In effect, the supermajority requirement is a floating number. We don't know exactly what that supermajority requirement will be for passage of the amendment until all votes have been tallied and we know how many people voted in the election. So there are some barriers that make it, obviously it's a complex and lengthy process. It's not designed to happen easily or overnight. Those are the very important parts to remember. Another small nuance is that when the legislature proposes the amendment, it can also pass legislation, amendments to statutes and other enabling legislation that will take effect only if the proposed amendment is adopted. So if the voters pass it, that can then act like a trigger to enact further legislation necessary to implement the proposed changes.
Once a majority of those voting in the election approve an amendment, the results are reviewed by a state canvassing board, and the amendment takes effect immediately or at a time specified by that amendment. There is one other way the Minnesota State Constitution can be amended. However, it's a rare procedure that has never been fully implemented.
There is an alternative process that is even more complicated and is established within the Constitution. It is available, but has not been used. And it basically allows for the calling of a constitutional convention to, in effect, rewrite all or significant parts of the Constitution. It's much more complex. 2/3 of each chamber of the legislature has to agree to call for the convention. Delegates are then chosen in a manner that the legislature would provide by law. We know that from the Constitution, there have to be as many delegates as there are members of the state House of Representatives. And the Constitution has to occur within 3 months after the decision to call for it. That could involve, as I said, a total rewrite of the state constitution. I think that the idea behind it is where wholesale change would be required, this might be the best method for accomplishing that, rather than a series of smaller ballot questions that eventually become complex if they're trying to accomplish many different things. Once again, once the convention completes its work, the proposed set of changes has to be placed before the voters in order for those changes to become law.